Dr. Diamond was such a central part of this request for a new trial in that the defense claimed that they were unable to put him on the stand, mostly because they felt like the information that they were forced to give over put them in a very disadvantaged position. Now, the prosecution, of course, is claiming that this was just trial strategy and perhaps they regret it now, but that's not grounds for a new trial. So I want to get your opinion here. The question is, should they have had to give over any notes that the doctor had as far as interviews with the defendant in this case, or do you think that was an unfair advantage for the prosecution?
Speaking to California law, which I know, in California, we would have to turn over any notes that an expert would have prepared in forming their opinion testimony for a trial. So in this instance, yes, I think that the prosecution was entitled to those notes, even if it was notes about what the words were of defendant Ross Harris. You can't, you're putting the prosecution at a severe disadvantage by saying that they cannot have the underlying work product in order to effectively cross-examine this expert. So I think that the court was correct in its ruling that in order for this witness to testify, you would have to turn over all of his work product in order to give the prosecution a fair opportunity to cross-examine.
Yeah, Marcia, one of the things that the ADA did in their argument was really lay out a number of reasons why they ended up not calling, or at least in their mind, why they wouldn't have wanted to call Dr. Diamond, not the least of which that some of the things he was going to say was going to contradict another, Dr. Brewer, who was on the stand. He was another expert called by the defense, as well as a number of other reasons. And I think it's fair to say, when you're looking to get the court to say that this was an error, that's really what you needed to do. You needed to show this judge that there could have been plenty of other reasons. And with those sitting there, it's going to be hard for the judge to say, hey, I made a mistake, and this was the exact reason why they didn't call him to the stand.
Well, the good news for the defense in this fact situation is that if they're arguing ineffective assistance of counsel, it's good to get the doctors not being called into question as to whether or not that was whether it was trial strategy or it's ineffective assistance of counsel. I find that it would have been ineffective assistance of counsel, and that takes the pressure off of defense counsel having to argue that the judge actually made a mistake. Because keep in mind that the motion for new trial can be granted even if the grounds is ineffective assistance of counsel. So I think if you're looking not to upset the court or to call the court on its rulings, the ineffective assistance of counsel of not calling Dr. Diamond is definitely the argument you want to make.
Yeah, and it looks like he went ahead, Maddox, went ahead and threw himself on the sword by saying he made this decision and it was an ineffective decision. But one of the interesting arguments made by the prosecutor was that they actually did that as sort of a built-in appealable issue. The fact that maybe there was this conspiracy by the defense when they realized what they had to turn over. They definitely didn't want that brought out in court. So they deliberately didn't call him so they could create this appealable issue based on ineffective assistance of counsel. So, Christa, I want to ask you, is that possible? Do defense attorneys sort of conspire in that way? Do they think ahead? Can they think 4 or 5 moves ahead in that way?
Well, I don't know if that's strategic chess or not. I think that would further the argument of ineffective assistance of counsel. Having said that, I think her better argument, instead of this conspiracy theory one, was that you can't object to the court's ruling on turning over the notes without hearing what the doctor was going to say. So you have to put that witness on the stand and go through the motions of having that witness testify, and then you can see if it would have affected the trial. Right now, you don't know. You're asking the court to speculate on her rulings on this issue, and whether or not it would have changed the outcome of the trial. And so I think that the arguments with respect to Diamond are better in that respect than this whole conspiracy theory, avenue, which I think is, kind of fun to make, but I don't know how legally sound it is.
Yeah. Now, Marcia, if you actually put him on the stand, then it sort of removes this opportunity to argue ineffective assistance of counsel, does it not? Which you say is really their best sort of avenue to get what they want out of this argument.
It is, but you could still argue, even if they called Dr. Diamond to the stand and allowed the defendant's statements that were provided in confidence to Dr. Diamond to come in at trial, that they could probably still argue that it was ineffective to have called Dr. Diamond, knowing what the court's ruling was, that his notes were to be turned over to the state, giving them a bird's eye view into what statements the defendant made.
So do you also think it was a mistake not to call him? Do you think they should have called him anyway?
I think they should have called him. And the reason I think they should have called him is because I absolutely believe that if jurors heard testimony from an expert stating that it is totally plausible for a parent, if they're distracted, to leave a child in the vehicle, especially based on the relationship with the child prior to this incident, that jurors may have found some type of negligent homicide or something lesser that would not have been such as severe as the mens rea required for him to have intended to kill the child.
Yeah, I'd have to agree with you there. Certainly it was important testimony, especially at that time when I think now it's a little bit more of an accepted knowledge that these things happen. But I think back then it was not so much. All right, we're going to take a quick break. Marcia and Christa, please stand by right now. We're going to continue to dig in to some of the arguments made in this seeking of a new trial by Justin Ross Harris. So please stay with us here on Court TV.